Oyez, oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Before we call the case, I'll just mention a couple things. We don't anticipate any technology-related problems. Things have been working very smoothly. But if we should have anybody, everybody just take a deep breath and we'll work through it and resolve it and pick back up. If you would call the case, please.
The In Re Demoni J. et al.
We'll hear from the appellant.
Good morning, Your Honors. May it please the court. My name is Ben Houston, and I'm here on behalf of the mother, Atia L. And Your Honors, the trial court has erred in numerous reasons in this case, and there are numerous reasons why this court should reverse the trial court. First of all, the record in this case creates substantial doubt as to whether the findings and conclusions in the written order of the trial court represent the trial court's own deliberations and decision. And as a result, this court should reverse the termination of the mother's parental rights. As is detailed extensively in the brief, entire paragraphs were lifted from the DCS petition to terminate parental rights and placed on copied verbatim into the trial court's order terminating the mother's parental rights. This is similar to what happened in the cases of In Re Colton B as well as In Re Marnisha D. Another huge concern in this case is that there was a ground for termination found that was included in the department's petition that wasn't even discussed at all during the trial in this matter, which obviously raises a huge question as to whether it creates substantial doubt as to whether this is the product of the trial court's own deliberation as opposed to what the Department of Children's Services determined.
Excuse me, we're interrupting counsel. With reference to that latter ground, it's my understanding the trial court did not address it and did not terminate parental rights based upon that ground. Is that correct?
My understanding is that there were three grounds that were found. That there were the grounds of the failure to provide or abandonment based upon failure to provide suitable housing. There's substantial non-compliance with the permanency plan pursuant to 36-1-113 G2. There were persistent conditions. And there was also the ground of failure to manifest an ability and willingness to assume custody. With regard to persistence conditions, it's my understanding that the court did find that ground despite the fact that there was no reference to this ground in the bench trial, which once again, in my view, creates substantial doubt as to whether the order was the products of the trial court's own deliberations in this matter based on what occurred at the trial.
So with respect to persistent conditions, the trial court did not address that in the oral ruling, but it is referenced and addressed in the final decree. Is that correct?
That's correct.
And then the trial court apparently did not find willful failure to visit. Is that correct?
I think that is correct.
All right. Thank you, sir.
With regard to the abandonment based upon the mother's alleged failure to provide a suitable home, we would argue there's insufficient evidence to support termination in the record. The fact is that the mother did actually have housing at the time of the trial. There was also evidence that the mother had income through her employment with the Crown Plaza Hotel. The mother also consistently visited her children, and she had completed required parenting classes. She had completed intensive outpatient drug treatment in the outpatient drug treatment program, and she had also completed a mental health assessment. For the same reasons, we would argue that there is insufficient evidence to support substantial noncompliance with the permanency plan. Similarly, we would argue that there is not enough evidence, insufficient evidence to support the ground of persistence conditions. With regard to persistence and conditions, we'd also point out that, once again, this ground was not addressed in the oral ruling from the bench. It wasn't even addressed at trial whatsoever. So based upon that, we would cite to the case of In Re OW for the proposition that this is a substantial discrepancy, and therefore that ground persistence of conditions should not be allowed to be a basis for termination, even if there arguably was sufficient evidence. But in this case, we'd argue there was insufficient evidence. Similarly, we'd argue there's insufficient evidence with regard to the ground of failure to manifest an ability and willingness to assume custody. I also want to focus, Your Honors, on the fact that the trial court relied upon the incorrect best interest factors. The trial court should have relied solely upon the best interest factors that were in effect at the time of the termination of parental rights trial. Instead, the trial court appears to instead rely heavily on the new best interest factors. This was an incorrect application of the law, and we would argue that also serves as a basis to reverse this termination of parental rights.
Counsel, sorry to interrupt you. On that, were the pre-April 21 best interest statutory factors, are they included in the post April 21 factors?
Your Honor, I'm sure the state's going to argue that there's always a catch-all in terms of the factors are not exclusive in terms of the court can rely upon other facts when making a best interest determination, because there is the allowance for the court to consider other facts beyond what the factors set forth. But they are a different set of factors. So I don't think they are exactly the same. And I think,
well, I mean, excuse me, I don't mean to interrupt. I didn't make my excuse me, my question wasn't clear. Are the factors in the pre-April 21 statute included? I understand there are additional factors listed in the post-April statute, but are those in the pre-April statute included in the revised version of the statutory factors?
I think some of them are, but I don't know that all of them are. I think there are some that are not included.
Can you tell us one that the trial court found that was just in the post 21? Excuse me, can you tell us any pre-April statutory factors that were not included?
I can't off the top of my head, Your Honor. If the court wants additional briefing, I could provide that, but I don't have that off the top of my head.
That's fine.
As far as best interest, once again, for many of the same reasons already pointed out, we'd argue that there was insufficient evidence to support a best interest finding, putting aside whether or not there was an abuse of discretion as it relates to the application of law and the use of the correct best interest factors. As already pointed out, the mother had housing. She had done all of these things that were required of her by the permanency plan, by the department, in terms of getting a mental health assessment, going through an inpatient drug treatment program, intensive outpatient drug treatment program. There was also things I think that were glossed over by the trial court, including the fact that DCS's own investigators witnessed unsecured prescription medications in the foster home, as well as the fact that one of the children, in this case, had unexplained scratches on his arms while in the foster home. I don't think there was enough emphasis by the court on those issues. Finally, I really want to highlight the fact that in this case, fundamentally fair procedures were not at play here. We would argue the mother was denied her right to fundamentally fair procedures. And perhaps the most egregious example of that is the denial by the trial court of the mother to have any closing argument. And I know that the state is going to argue, well, she's waived that. But if you look at the transcript in this case, there was no opportunity for the mother's counsel to even object or to even say anything prior to the trial court immediately after the close of proof launching into its oral decision from the bench. So there are a number of states that have held, and keep in mind, these are in context, civil context that are actually involve less constitutional concerns, arguably, than termination of parental rights cases, which have been likened by at least one court to being the civil equivalent of the death penalty. But courts in Maryland, Florida, North Dakota, and Georgia have all held that it is reversible error to deny the right of a litigant, even in a bench trial, to have a closing argument. And when it comes to a termination of parental rights, which has been likened to the civil equivalent of the death penalty, I would argue it is a violation of fundamentally fair procedures to deprive the mother and her attorney the right to even make a closing argument, put all of her arguments before the court prior to the court making a decision. So for all of those reasons, Your Honors, I would ask that the court reverse this termination of parental rights as to the mother.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
May it please the court, I'm Catherine Baker here on behalf of the Department of Children's Services. And Your Honors, I want to start by clarifying a few things, going back to Judge Frierson's question about which grounds were pled and found by the court. So the department pled failure to support suitable home, permanency plan, persistence of conditions, and failure to manifest. So the court did not find the ground of failure to support for mother. Failure to visit was only pled against the father. And in its oral ruling, the court found suitable home, the permanency plan, and failure to manifest grounds, but the persistence of condition ground does appear in the court's written order. So going to whether the trial court's ruling is truly an independent ruling that mother alleges it is not, I would point out here that this case is distinguishable from the two cases that mother relies upon, Marnisha and Colton B. In those cases, this court found that there were pretty much no findings of fact, or very, very sparse findings of fact in the court's oral rulings. In this case, there are 7 pages of oral rulings regarding the mother, which is very distinguishable from those other cases. The court made specific findings of fact in its oral ruling that then do appear in its written ruling regarding the grounds and best interest factors, and including the fact that the court found that mother was not a credible witness at all. The court credited the other witnesses, but in its oral ruling and in its written ruling points out that it did not find mother credible at all as a witness. So The court's oral ruling and the written ruling line up closely enough. It is clear that this was not simply a copy and paste job from DCS's petition into the written order. There's significant recitation of the testimony from trial in the court's written order, plus the facts from the court's oral ruling.
Counsel, the court didn't request from the parties a proposed order or anything like that at the end, did it? In other words, you gave it oral ruling and then drafted and wrote the written order.
I believe the court requested that DCS write the written order based on its oral ruling.
Oh, so the court did ask DCS to do that.
I believe so, Your Honor, yes.
Well, if the trial court never mentioned persistent conditions in its oral ruling, where did DCS get where did they get to put that in the written order?
Yes, Your Honor. The department acknowledges that that is a substantial difference between the oral ruling and the written ruling. And I won't speculate as to how it ended up in the written ruling,
I understand.
as I did not write the order.
I understand.
But I would remind the court too that termination need only be based on one ground. And there are 3 other grounds that were included in the court's oral ruling here and appear in the written ruling as well. And I don't believe that the persistence ground being in the written ruling is enough to necessitate remand for entry of a new order, which is what this court has done before when there's been some mismatched findings between the oral ruling and the written ruling, because there's substantial evidence to support those other 3 grounds and to reflect that the court did make an independent finding on those 3 grounds and the best interest factors. And by this point, these children have been in custody for over 3 years. And this court in the past has said that as long as there is at least one ground and the best interest analysis supports termination, we don't want to prolong these cases any more than we have to be able to give permanency for children as soon as possible. And so as long as there's an independent basis that can be seen from the record and from the court's ruling, the department believes that the written order is sufficient here. Moving on to the grounds. So I'll discuss the 3 grounds that are in both the court's oral ruling and the written ruling, starting with suitable home. So the children were removed in November 2018, and they were placed in DCS custody pursuant to a court order and a dependency and neglect petition. DCS made reasonable efforts throughout the entire case, as evidenced by the ratification orders that are in the record in the exhibits. Those reflect that DCS's efforts include providing mental health assessment for mother, mental health counseling, bus passes, visitation, and alcohol and drug assessment, drug screens, basic parenting instruction classes, and child support services, as well as alcohol and drug treatment for mother. Mother admitted that DCS paid for services for her during the trial. And despite all of these services that DCS provided throughout the entire custodial episode, mother failed to establish a suitable home even by the time of trial. This case began when mother was not appropriately supervising her children. They were found wandering in a parking lot. At that time, they were only 18 months and 3 years old. And DCS first provided some non-custodial assistance to mother by helping her place locks and door alarms on her doors to keep the children safe inside. And yet when DCS went back to check a couple times, and then in October of 2018, the children were left unattended again without appropriate supervision. And that's when they entered custody. And by the time of trial, mother still was not appropriately supervising the children or providing proper parental guidance, as was seen during visitation. The 2 visitation supervisors from Child Help who testified at trial. One of them supervised visitation for about 1.5 years. The other one had been supervising visitation for 5 months. Both of them said that mother was not exercising appropriate parenting skills. She was not able to appropriately supervise them. One of them testified that he would have serious concerns given the children's needs and behaviors, that if mother were to have custody of them, he would have very serious concerns about their safety. The other specialist also testified that he had concerns as well. And for example, during visitation, mother would throw balls at the children's faces, act more like a peer than a parent, and the children would become very dysregulated in their emotions. And so there were still those concerns that mother could not appropriately supervise these children and provide them with a safe home. She was also, one of the things that mother lied about during trial was her relationship with a man named Ramon, who had been convicted of shooting mother, and in December of 2020, I believe, which was a few months before trial. And she first denied knowing this person, but then admitted she did know him and had vandalized his sister's car. And mother was still living with this person, as seen by the private investigator that DCS hired, who saw him at mother's apartment multiple times, despite mother claiming that he was not there. Mother had also admitted to her landlord, and the landlord had told DCS that this person was living with mother and he was her boyfriend, and there were domestic violence issues that DCS was concerned about there. And mother was also facing potential eviction at the time of trial, which she admitted to. So regarding the permanency plan, a lot of the same facts support this ground as well. Most importantly, again, even though mother completed some assessments and completed parenting classes and completed some treatments, again, she was still not in a position to be able to care for these children. And as this court has said, the permanency plan is not just a checklist of items to be done. It's an outline for doing the things that are necessary to be able to care, to resume caring for the children on a day-to-day basis. And mother did not do that. Again, her parenting skills were still lacking, and that was one of her responsibilities, is that she was supposed to demonstrate parenting skills during visitation, and she did not. Again, her housing was not stable, as she was again facing eviction, and there were those domestic violence concerns. Also, she had failed to provide proof of her employment to DCS throughout the case. She claimed employment at many different places throughout the case, but she failed to provide proof of most of it. And at trial said she had just started a new job 2 weeks before trial. She also failed to attend therapy for about 6 months, and at trial claimed she was attending Cherokee Mental Health for services. And yet when DCS contacted Cherokee said they did not even have her in their system, showing that she'd ever been there. The failure to manifest ground, mother failed to demonstrate an ability and willingness to care for these children. Again, regarding ability, facing that second eviction due to fraud. Actually, that eviction, she had claimed the child on her lease when the children were not living with her. She did not provide proof of employment to DCS and did not have steady employment. Mother had also been charged with vandalism, as I mentioned earlier, against Ramon's sister's car. She had vandalized that car and pled guilty to that charge. She also failed to demonstrate a willingness, as seen by her failure to seek mental health treatment, her lying about her relationship with Ramon and not being very truthful to DCS and to the court. And the court found that these children will be at a risk of substantial harm if they were returned to mother. due to those domestic violence issues, and also mother's very lacking parenting skills and lack of proper supervision. So regarding the best interest factors, the court stated that it was this at the end of its oral ruling, the court stated that the new best interest factors incorporate all 9 of the old best interest factors. And I think my findings would work either way, and they would be identical. And so even though the court did consider some of the new best interest factors, it also made findings that would have fit under the old best interest factors, specifically factors 1, 2, 4, 5, and 7. The court made findings under those, and then additionally considered some of the new best interest factors. And the court, even before the statute was amended, could consider additional factors in addition to those what were the old 9 factors. And so the court could appropriately consider any additional factors here. But even under those factors 1, 2, 4, 5, and 7 of the old factors, that's more than enough to show that termination was in these children's best interest. Under factors 1 and 2, mother did not make an adjustment of her circumstances even after help by DCS. I outlined DCS's assistance earlier under the suitable home ground, and those apply here as well. And again, mother's circumstances were very similar to when the children entered custody 2.5 years before trial. Mother was again facing eviction like she was when the children entered custody. She still could not appropriately parent these children and provide them with any safe living circumstances. She was not attending mental health treatment, and there were those domestic violence concerns. Factor 4, mother did not have a meaningful relationship with these children. One of the child.
Counsel, before your time runs out, let me suggest you address issue 8 that they raised as to the fundamentally fair procedures.
Yes, Your Honor. So there were fundamentally fair procedures here. And regarding the closing statement, mother's counsel at trial did not object or request a closing statement. So they waived that issue. To the extent that mother might be claiming ineffective assistance of counsel, Carrington H. forecloses that argument. And mother really fails to demonstrate how this was prejudicial to her at all, beyond making broad stroke arguments, but can't point to anything specifically that would have prejudiced her in the termination of parental rights trial or the court's final ruling. And for all of these reasons, the department asks that this court affirm the trial court's order terminating her rights.
Counsel, we'll hear from the appellant in rebuttal. Mr. Houston, you're still muted.
Yes, Your Honors. To briefly touch upon some of the issues raised by the state. First of all, with regard to N. Ray Colton D. and Marnisha D., while it's true that those rulings did involve perhaps oral rulings that contain sparse findings of fact, I would argue that this case, in a lot of respects, creates even more doubt because in neither of those cases, in both of those cases, the grounds that were found in the oral ruling matched the grounds found in the written order, the final written order. In this case, we have a ground that wasn't mentioned at all at trial or referenced in the oral ruling that found its way into the final order. And you know, even it's not merely enough, I would argue, to set a substantial doubt as to whether or not this final written order was the result of the trial court's own deliberations and decisions. With regard to the housing, I would point out that there had not been a final eviction order at the time of trial. That was speculation as to whether or not there was an eviction proceeding, but I would argue it's speculation to assert that the mother was going to be evicted, which is what the trial court found. I would argue that was not appropriate for the court to speculate on that basis. And finally, Your Honor, I do want to go back to issue 8, which I think is a very critical issue in the closing argument. Strenuously disagree with the notion that the mother waived any argument with respect to the right to present a closing argument. The opportunity to present a closing argument.
Well, counsel, I mean, couldn't the lawyer have spoken up and just said, Your Honor, we'd like to have closing arguments? I mean, I understand what you're saying, that the judge started the ruling, but couldn't the lawyer have said something?
Your Honor, I would argue it's analogous to State versus Skelton, where the same argument was made by the state in that case, and the Court of Criminal Appeals found that by the time the mistrial was declared, the horse was already out of the gate. We got the same situation here. The horse was already out of the gate. The trial court had already made its ruling. So I do understand, I guess the idea she could have interrupted the judge, although sometimes judges
Politely.
But there are instances, that I think that it's a stretch to say under these circumstances that she waived anything. To the extent that she did, I'd argue too that this court has held in certain circumstances that even if there is a waiver, that you still have to address that issue. Circumstances like the lack of transcript, for example, where this court has reversed termination, parental rights findings where no transcript was filed, even though that was the appellant's responsibility. Also,
Counsel, your time has expired.
thank you, Your Honor.
Thanks to counsel for both sides. We appreciate your oral argument this morning and your briefing on this. If you would please recess court until our next scheduled case.
This Honorable Court of Appeals is now in recess.